All right, ladies and gentlemen, welcome. We're here to cover some hard topics in contracts law, which is a corroboration between Cooley law professors and LexisNexis. Okay, so this looks like it's the third time I've given this. There are PowerPoint slides to accompany this presentation. In case anyone would like to work with those, I can make those available later. The idea is hard topics in contracts law, but I'm actually going to start with the easy ones. And the reason why is because, especially if you're looking at an essay, and you have a contracts essay on the Florida bar, there are certain points that you should not miss. You should not miss. And so things get harder as we go along, but we start up front with what you should do first. All right? And I've reviewed a fair number of Florida contract law essays, so I know that of which I speak. First, are you dealing with the sale of goods? Because if you are, you want to mention the Florida adoption of the Uniform Commercial Code. Don't say UCC. Don't say Uniform Commercial Code. Say Florida adoption of Article 2 of the Uniform Commercial Code. Because the states have adopted the model code that you've studied from with almost no differences. Okay? And what happens if the UCC in Article 2 doesn't cover an issue that you need? For example, like the defense of misrepresentation. That's not in Article 2 of the UCC, and yet it happened in a sale of goods case. What do? Yeah, you can use the common law where it's silent, and the code section is 1-103B. I think in Florida it's 671.103 sub 2. It's slightly different. Same words, same format, just different numbering. Okay? But if you say the Florida adoption of 1-103B, you'd be spot on just as well. Okay? All right. If you're dealing with services, employment, construction, those are going to be common law. And you should say that up front. This looks like a services or an employment agreement or construction services, and therefore the common law principles are going to dominate or going to control the resolution of this issue. Sale of goods, of course. Do you remember the definition of sale of goods? Anything movable at the time of purchase or at time of contracting, something like that? So, good enough. Florida, as virtually all other states, have a hybrids test. What if it's about 2/3 services and 1/3 product? What if you're painting my garage, but you're also making the paint for me?
Depends on
Yes, Florida follows the predominance test. Whichever one seems to be bigger, often it's the value. But sometimes it's maybe the values are close. Maybe the goods are worth 49%, the services are worth 51, right? Or vice versa. Goods are 51, services are 49, but the services are going to take 6 months to complete. You see how that might make services the operative in a hybrid situation?
Would it be safe to say to look at the purpose of why you got into the contract in the first place?
That's all of it's part of it. Look at the price, look at the timing, look at what your reasoning was. Did you have your house painted and then the painter said, I can actually make you the paint? Or did you go to the paint store first and then the paint store said, I got a guy who can paint for you? That would show different purpose from walking into the store. That's a factor, but it's not dispositive. So you've got to balance several things to see which one's predominant. And sometimes price makes it clear, other times you've got to balance other things. Now, for final points in that little regard, what else should you say about other states? Florida follows the predominance test, but other states, in what looks like a minority, would instead, what would they do? They'd use UCC or the state adoption of it for the goods part, and they'd use the common law for the services or employment or construction part of it. And if you say that, you're garnering points. You just told the Florida bar examiners it's a predominance test majority, and you explain what the minority is, right? Easy points. And you're supposed to be doing this right up front. Okay? Tell the bar exam reader why. Where you are, why you're there. Okay? Makes sense. Second main thing that you should probably do up front. Identify the area of contract law that you were in. If you had me, you started getting used to boxes. You understand that there are 8 or 10 different boxes, maybe a few more, of which you need to be aware. And you try not to confuse concepts. All right? If you're talking about breach, please don't go into the defenses to enforcement box. If you're in conditions, please don't go into the breach box. And so this is looking at it's a bird's eye view. Can you tell the bar examiners, not only common law or UCC, what area you're supposed to be talking about? Can you do that now? It's not that complicated, but you have to start thinking about it now before you take the bar exam. First, is it a formation issue? What do you know about formation?
The things that you're gonna need in order for the contract to be valid.
What does Florida say about the fourth element? You've got offer. What are the components of offer?
You have to communicate it.
You've got to be a current intent. If you miss that, you're out. How do you measure the current intent?
Objective
Yep. Then you've got what?
acceptance.
No, you still got a component. Now you've got communicated. And what do you have as a third component of offer? Definite terms? All right. Acceptance. Almost the same thing, except for the third component, which is different. What do you want to say for the third component of acceptance? I know I'm going over this quickly. We need to, though. I tell my students not to say mirror image rule first. Right? What is definiteness? If definiteness is what an offer needs to be, what does an acceptance need to be? Begins with an R and rhymes with responsive. Do you remember that? You've got to give back your acceptance in the way or close to the way that the offeror expected it. If you want to sell me your car for $5,000 and I hand you $3,000, do we have a deal?
No.
Because it's not. Begins with an R. Now, what did the old days use? Not the responsive rule. And what could an offeror demand if he or she has a specific way of accepting and demands that it be accepted that way? And that's not yet. Mirror image. Remember the mirror image?
Yeah, it's not like common law.
Yeah, but it's not dead yet. The offeror could say, I want you to accept only this way, and it must be in my hand, it must be in red ink. And if it says that, that's the way it's got to be done. That's a mirror image issue, not a responsive issue. Responsive means close enough. Mirror image rule means exact. Okay? Third element, consideration. What are the 2 things you need to add for consideration? Not that I won't go into them, but what are the 2 words you need to remember right away?
Benefit and
That's what it is. That's a definition. Right? It is the quid pro quo.
the bargain exchange.
I want you to remember legal sufficiency and adequacy. Do you recall that? If it's legally sufficient, don't go into adequacy. If it's not legally sufficient, if there's a large disparity in value, you want to think about the adequacy question. Doesn't mean that it's not consideration, but the courts will go a little further into determining whether or not it works. Now you've got your 4th element. What is it? In Florida, you say, you're all taking the Florida bar, right? Florida wants you to say sufficient specificity of essential terms. Sufficient specificity of essential terms. Which, and I found a case in Florida that says this, is really not different than the mutuality meeting of the minds. Are you recording this, by the way?
Yeah?
You're not allowed to.
Okay.
It'll be on this. No, you have to ask first. To record me, you always have to ask.
Okay.
But it's being recorded now. Okay?
Okay, great.
So,
Repeat that, Professor.
sufficient specificity of essential terms. Okay? But the good news is, if you use that language and you say, it's really a lot like other jurisdictions' meeting of the minds, you would be on safe ground. Okay? But then what you show is you'd show that the specifics that Florida would prefer. Okay? Then if you have a formed contract, you might ask yourself questions about breach. Has something not been honored? And if there's a potential breach issue, if it's a sale of goods, you're probably going to have a perfect tender rule problem. What do you know about the perfect tender rule with sale of goods?
It's delivering perfect goods.
The standard is has to conform with the terms of the contract. All right, that's the standard. Conform with the terms of the contract. And if something is delivered and it does not, what is the buyer allowed to do?
Accept some, reject some.
Take all, reject all, or take any commercially reasonable unit. Correct. Okay? Another area of breach, and this is testable, is anticipatory repudiation. What do you know about anticipatory repudiation? You tell me. I'm going to keep it short.
Basically, somebody says they're not gonna perform.
And if it's unequivocal, what do? When they tell you they cannot perform, they will not perform. You can either wait or treat it like breach right there. Your choice. But you see how that's your choice, right? The non-breacher's choice. What if they say, there's a storm, we think we're going to be late? And it's sale of goods, so tender of delivery could be a week late. Well, you have to argue that it may be equivocal rather than unequivocal. And then you're right. If it's equivocal, then if you've treated it as breach, you've become the breaching party. Haven't you? And to avoid that, you ask for adequate assurances. Which, if the other side doesn't answer reasonably, you can treat as breach. Now, there's some more details to that. Not going to get into it. If you knew as much, if you remembered and knew as much as what we just said, you'd have the proper format to do a good job on an essay question, or do a good job even answering a multiple choice. But there's some timing issues, etc. I don't want to get into right now. But when it comes to breach, the two major issues that I tend to see, at least for sale of goods, is the perfect tender rule thing, and it's standard, right? And the potential of anticipatory repudiation. Next major issue, and now we just get to nearly the end of contract 1. We cover damages. And what do you need to know about damages? Well, first, let me make this easy for you. To be honest, with a few tweaks, the UCC type damages are very, very similar to the common law ones. What do you know about UCC damages? They don't like giving restitution. What is the goal of damages, by the way?
Yeah,
Would have been in had the contract been fully performed, right? No windfall, no punitives, correct? What is the terminology you want to use if you're in the common law? Where do you start first from worst to best? That's the best. Worst is restitution, then comes reliance, somewhere in the middle, then expectation. Break down expectation into two. Natural flow and, not general, but special. Special. And what do you need to do with special damages? Like the loss of a third-party contract. Certainty, foreseeability, avoidability. Don't say duty to mitigate in Florida. There is no duty to mitigate. Now, if it's a natural flow damage, you don't have to worry about those tests. Everyone knows if they don't honor the contract, let's say you made a deal with somebody and you saved $1,000, right? And they breach. What have you lost? That $1,000 good deal, correct? Is that a natural flow? It is. Certain, you don't even have to worry about that. Foreseeable, don't have to worry about that. Avoidable, don't have to worry about that. But then you look at the other kind. Like, if you don't give me those widgets in time, I can't put them in my blenders, and I'm going to lose a big contract with China. That's a special damage. Okay? And for those, you've got to check certainty, foreseeability, and avoidability. Use avoidable. Try not to say duty to mitigate. It's really not a duty to mitigate in Florida. It's avoidable. And the idea is, if you could have avoided a damage and you didn't, you don't get that damage. Okay? Now, for UCC, boy, I just gave a presentation on this in equities class. Too bad there's not a lot of time. The UCC does not provide for restitution damage. Can you still get it if nothing else works?
Yes.
Why? Remember 1103B? I said if the UCC doesn't cover it, you can supplement with the common law.
Okay.
That's how. But there's a prejudice against restitution and reliance. The UCC tries to force everybody to go into expectation damage,
Okay.
right? And expectation is, there's the seller ones. You can resell, you can not resell but get your benefit, or if you're a high volume seller, you can get lost profit. Those are the three main things a seller can get for legal damages. That's the money kind. Plus, do they get incidentals and consequentials? Trick question.
Should be into, yeah.
Seller only gets incidentals. Seller does not get consequentials. Why not? They know better. When you go into a contract, you know that it's quite likely that the other side's going to breach. So you do not get expectation damage. You cover it by insurance, you do it some other way. Sellers do not get consequentials. Now let's get to the buyer. The buyer can cover, right? Or the buyer can not cover, but still get the benefit of his or her bargain. What's the benefit of his or her bargain? If I signed a contract to buy something from you for $10,000, and I don't buy it, and you breach, but I don't buy it. But if I could buy it, it was $12,000. What's my loss right there?
2,000.
That's right. Right. That's the loss of the benefit of the bargain. The buyer can get that as well. Buyer can cover, right, plus incidentals and consequentials. Buyer can do nothing but get the benefit of the bargain, plus incidentals and consequentials. And what's the third thing the buyer can get? Let's say you keep the goods, but they're still not exactly what you wanted. Begins with a W.
Waivers.
Warranty. You can sue on breach of warranty, right? Any warranties they give you that are express, any warranties that are implied, like the implied warranty of merchantability. So I just gave you the 3 seller damages, I just gave you the 3 buyer damages, right? And if the buyer's looking for consequentials, the buyer also has to put it through seller or buyer, even in those cases. If they're looking, well, seller doesn't get consequentials. But if the buyer's looking for consequentials, certainty, foreseeability, and avoidability still applies. The UCC doesn't say that, but the common law applies in that regard. Okay? What else? Any other kind of damages? Let's say legal damages just don't work. Does the UCC allow specific performance?
Only if the money that you can't get any money back.
I like what you said there. No adequate remedy at law. At common law or UCC, you can get equitable remedies. Okay? For the seller, there's a provision in the UCC Article 2 that talks about the action for the price. What is action for the price? Specific performance. What does the buyer get? The buyer can, if the goods are identified to the contract, the buyer can actually get the goods out of the seller's warehouse. What does identified to the buyer's contract mean? Let's say I'm going to sell you 1 million light bulbs. When are they really yours? When do you have an insurable identifiable interest? When they're in the truck on the way to you? When they're at your loading dock? Where? When I slap your address on the box in my own warehouse. And if you've identified them and they're still there and they're not destroyed, you might even talk a court into making me turn those over to you because they've already been identified to your contract. Okay? So there are provisions for equitable damage in both, well, it's common law, but it also applies in the UCC. All right? Next major area of contracts law. I'm going to skip statute of frauds and bounce. I'll cover that in the defenses now in contracts 2. We've just moved into contracts 2. We have another box we need to worry about. Integration and interpretation. What's the difference? And if you know this, you won't be scared when you get a problem on the bar exam because you'll know how to address it. They are related. One is a subset of the other.
Integration is whether the term or whatever it is in the contract, and interpretation is what it means.
Right. When you're looking to see whether or not it's in, it's integration. And you probably want to mention the parole evidence rule. If there's something that's clearly in the contract, but it's ambiguous, then you engage in interpretation. Okay, good. You can set it up so it's both. right? I could set it up so you have to ask integration. Is that term in the contract from a prior email? And then have that term be ambiguous, so then you also have to interpret it. Wouldn't that be ugly? But it could be done. Okay, next, you jump into the area of conditions, another big area. Now, I want you to try and focus on differing language. When you talk about obligations, like promises or performances, and they are not done properly, you want to call them breaches, all right? When you're dealing with conditions, I want you to call them failures. Failure of condition, okay? Because their mechanics are incredibly different, and if you don't have a clear sense of this writing your essay, you're going to write a bunch of word soup that's not going to make sense. So if you got an obligation that's improperly done, it's a breach, right? And you sue for damage. What do you do with how does a condition work? What if a condition fails?
Then the other person doesn't have to perform. The condition is based on.
We don't say breach, we say failure, but if a condition fails, what happens? Either it keeps a duty from arising, yes? Is that the same as breach? No.
No.
Or if there's an ongoing obligation already, it could cut that off, right? Or if it's concurrent, we don't have to worry about that. But do you see how one of them stops a duty, prevents it from arising, or shuts it off? Whereas if it's a breach, you go right after damages. But if you go after damages, does that absolutely shut off your duties under the contract? It actually might suspend them, but might not shut them down. So there's a difference in how they operate. Think of it this way. Well, that might take too long to get into. Let me think if I want to cover that. Do you understand the difference between the non-arising of a duty and the suspension of a duty? Do you understand the difference between those?
No.
Because with a breach of condition, it ends, or it keeps a duty from arising. What if you and I are performing all along, and then you breach? Does that mean I can stop sending you a supply? Or can I suspend it to find out what's really going on? See, there's a little bit of a difference there. I may not be fully freed of my obligations to you if they're promises in the case of breach. If it's a condition, stop, I'm done. If it's a promise, I may have to either suspend or keep performing at least some of the things because there's still going to be this process of working out the problem. Remember, when there's promises, they've already been made and they're ongoing. What's the big difference between a promise and a condition? Do you have to exercise a condition in good faith? Do you have to exercise an obligation in the contract in good faith?
Yeah.
Do you see a difference there? Conditions are harsher animals, right? Cutting off or failing to arise a duty. Can you give me an example of a condition?
What about when you were gonna sell me your boat and I was supposed to meet you at the dock at 10 o'clock with a check to.
And you don't show up.
I didn't show up.
So I don't have to say, well, who's the one with the check? You?
Yeah.
Then I don't have to sell you the boat. That's right. No duty. What if you showed up with a check, right? And I gave you a boat, but I promised I'd paint it, but I didn't paint it. Can you walk away, or might you still be required to take the boat and just try and lower the price you paid me? Or sue me for the breach of it? You see my point? See how there's a bit of a difference? One lets me walk away, or you walk away. The other one, you might not be able to walk away. You might get damages, but you can't walk away free and clear with no obligation anymore. Because when you make a promise, you promise to operate in good faith, don't you? When you put in a condition, you don't make that promise. Next major area of contract law. This is again contracts too. Rights of third parties. Does a third party have a right in your contractual relationship? The answer is sometimes yes.
Sometimes.
What are the examples? Just so you know. Life insurance. You owe me money. Don't pay me. Don't pay P. Don't pay me. Pay my brother. You live in this town. Don't give me the money. Give it to him because I owe him money. See how we involved a third party there? Question though, it's always this. Can that third party sue to enforce it?
Depends.
And there's a big depends there. Depends on the intent, right? Was that third party an intended beneficiary rather than just incidental, as an example? Okay? So there's the third party beneficiary scenario, and the question always is, can the third party sue directly? And there are certain vestings and certain abilities to where they can, and certain others that they can't. You'll pick up more of that in your bar review course, but understand it's one of the big issues that you want to get your minds around and recognize right away. The other form of third-party involvement in a contractual relationship is the assignment and delegation. And how do you recognize the difference between the two? It's quite simple. So now that you know it, or when you know it, it'll be easy, and you'll know whether you're going to be using language of third-party beneficiary rules, or in the alternative, whether you're going to be using language of assignment and or delegation. What's the big factual difference?
Assignment, you're assigning the right, delegation,
Delegate duty, with third-party beneficiary, you're still trying to assign a right, give someone else a right, aren't you? This gets a little bit complicated, and I'm not going to go too deeply, but this is the distinction I want you to have in your minds. You use third-party beneficiary rules when the third party is in contemplation at formation. So if I'm talking to an insurance company about insuring my life for you, are you in my mind when I'm signing that contract? You bet. That's third-party beneficiary scenario situation. What if I'm going to cut your lawn? We have an agreement I'm going to cut your lawn. Full stop. 2 weeks later, I get too busy and I want to assign my brother to cut your lawn. You see how the third-party involvement comes after formation? That's a big difference. During formation, third-party beneficiary rules. Post-formation, where you're trying to involve a third party afterward, is going to be either an assignment or a delegation. And it's a little fast and dirty, but I promise you, how many of you knew that until now? If you had my class, you might have remembered that. But most of the time, it's one big jumble. Now you know at least you can start using the appropriate terminology. Third-party beneficiary rules, where the person's in contemplation, either directly or incidentally, at the time of the making of the contract. And if the person is brought in after the formation, you deal with assignment and delegation. With regard to assignment and delegation, what do you know about assignment and delegation? Which one can you do almost all the time? Which one can't you do?
Most of the time you can always assign.
You can almost always assign, not always, but usually.
And
Delegation, it's not as easy. Why is delegation more difficult?
because it's a specific,
It's usually that delegation is some personal service. I don't want your partner, I want you. I signed up for you. But if it's just payment of money, who cares where the money goes? I send the check here, I send the check there. I don't care. That's why assignment's usually not a problem. But give me the rule where in both cases, either the assignment or the delegation would be a problem and perhaps not allowed. Remember I said usually you can assign but not always? Delegation's harder, but sometimes you can still delegate. What's the general rule where you cannot?
if the contract
Where either the assignment or the delegation will increase the risk of the other party, or increase the cost, or increase the trouble. Remember, like you ordered 5 trucks of pineapples. And you assign them to your competitor across the street. Can you do that? Sure. What if your competitor lives 3 states away? Is that going to cost more shipping? Is it going to cost more insurance? See the point? So even that assignment could increase the risk or the cost. And if that happens, then the assignment might be problematic. That's much more likely with delegation, but it can even happen with an assignment. Defenses. This is the last major topic of contracts too, right? So, before I finish defenses, well, I'll finish defenses, then we'll go back at it. There are a lot of similarities in the elements of defenses, but there are some real distinctions. Once you get your mind around them, they're easy to deal with. All right? And which ones do you know? Oh, by the way, here's another terminology trick that'll help you always keep these different, right? If there's a breach, you look for damages. Yeah? But if you're talking about defenses, you're talking about the inability of the other party to enforce. Let me ask you this question. Watch my lips. Does your inability to enforce a contract look the same as there's no formation, therefore no contract? Or do those lips move differently? Is there a difference between lack of enforcement and lack of a contract? Yeah, actually there is. So if you're in defense land, you want to say lack of enforcement. If you're in formation land, you say there either is or is not a formed contract. And how you say it is how bar examiners will determine whether or not, with the terminology you use, you actually know what you're talking about. And it's not just word soup. Yes, ma'am.
So you don't, okay, so I've done contracts already for my bar review course. So, and they say that there are defenses to formation, and then.
Well, they should be saying defenses to enforcement more than they say defenses to formation. And I can prove it.
Right, okay,
And I can prove it, but go ahead.
So in ours, it's under defenses to enforcement or whatnot, because the main question is whether or not is the contract enforceable, and then it says defenses to formation and under another step. So
When it says defenses to formation, does it say there's no formation? Or does it really say there's the ability to avoid the finding of formation based on the defense? There really is a difference. If there's no consideration, there's no formation.
Right.
If there is consideration, but the person was 90 years old and the preacher hoodwinked them in the deathbed, you've got undue influence, right? Now, what do you know about undue influence that you don't know, or that is different from when there's a lack of consideration and no formation? And if you understand this, you'll probably never forget the point or the difference between the two.
I don't know, I'm just thinking maybe that is a contract already, we had a contract or something, and then you're saying, okay, well, it wasn't okay, the contract is not valid because of this?
Kind of. But let me try this on you, okay? Let's just say that you have somebody who's 12 years old, and he or she enters into a contract to buy an automobile for $2,000. 12 years old but grows a beard.
Well,
Right?
That's not a valid contract because.
Oh, yes, it might be.
It's
Oh,
okay,
yes,
so
it might
can
be.
a valid contract, but it can't. It's either enforceable if the kid decides that they want to get out of it. They
That's
can
it.
get out of it.
That's it. The person has the option of getting out of it. If there's no formation, can they still enforce it?
No.
If it might be valid or not valid, might they, if they want to, be able to enforce it? See the difference? There's the big difference. And that's how you distinguish between non-formation and defenses to enforcement. Because you give you give the innocent party, in many cases, the ability to honor the contract anyway. Maybe they made a great deal. Why should the bad party get out of a bad deal when it's his or her own fault? We want the old lady, we want the child to be able to honor the contract or enforce it at their option. They get cut some slack, but not the other side. If there's no formation, neither can argue. The contract just doesn't exist. And that's probably why we have defenses to enforcement, right? Because if a defense works, they don't get hurt. But if they don't want to use the defense, they can actually enforce the formed contract. That's really the big difference. And if you use terminology right, no formation, no contract. Possible formation, but a defense to enforcement. And if you use those appropriately, you start sounding so smart that if you say that up front, this is not a formation problem, this looks like a defensive problem. We have an old lady and a preacher at the deathbed talking her into signing away her farm for $5. That looks like the defense to enforcement of undue influence. So it's not a formation problem. You stop right there and you just told them it's a contracts 2 thing, not a contracts 1 thing, as long as you're right. And they stop worrying as much about what you say below, because you've nailed exactly what you're supposed to be talking about. Okay? So, now talking about defenses, what are the most popular ones? How do you recognize them? There are only 1 or 2 defenses mentioned in the Uniform Commercial Code. Unconscionability, and they mention commercial impracticability, but they call it something else. Failure of a necessary and preconceived condition. I forget exactly what it's called, but it's commercial impracticability is what it means. And if I'm correct, it's in 2615, but I'd have to look that up again. There's unconscionability straight out. What are the defenses you know? We started with, in contracts, what did we start with? Fraud? Fraudulent misrepresentation. We had 3 kinds too, by the way, didn't we? Intentional, negligent, and innocent. And each one, the first one was the worst and probably allowed the other party to use the defense of that. No contract. Okay? And you saw somebody made a material misrepresentation that the other party knew about, relied on, and to their damage. There's a couple elements you got to kind of remember what those are. If you remember 3 or 4 of the 4 or 5 components of the ability to legally assert the defense of fraudulent misrepresentation, you'll be fine. Remember what they are, though? Can you remember that a little bit? Material misrepresentation. Material misrepresentation relied on by the other party to his or her damage. And there's one more even I can't remember right now. I haven't taught it in a while. But if you get 3 or 4 of those, you're still going to pass. If you put those down, you'll be fine. What's the next one we covered? I think it was... What was the one about?
Mistake.
Oh yeah, now remember, misrepresentation can include a culpable non-disclosure. When you have a duty to disclose and you don't, that's still a fraud or misrepresentation issue. So it's a subset of that. What's the next one we covered? Didn't we cover? We covered mistake, and there is the mutual mistake where both parties made. There's the unilateral mistake where only one party made it, but the other party should have known better. All right, you'll recognize that. Then we did, I think, undue influence. What do you want to see with undue influence? And this helps you remember the elements. You have to see some kind of a weak mind, somebody with some level of sway or power over the other person. Didn't I say a 90-year-old lady on her deathbed and her preacher at the deathbed making her sign over her inheritance? See the point? We had a weak mind. Yeah? And then we also had somebody who has the ability to, and then the motive to exercise some level of undue control over the weaker mind. And the weaker the mind, the less power the person has to have. The stronger the mind, the stronger must be the person's ability to overcome the other party's free will. All right? What else did we cover? And so the bottom line is, when you see some of these factoids, yeah, you know which one to talk about, which defense. So you see an old person, think undue influence. What about the gay guy who got fired and they came up and had him sign away his contract rights after he just gotten out of jail and had no sleep? Remember that? That was undue influence, wasn't it?
Misunderstanding is another one.
Well, I'd go with mutual mistake for misunderstanding, or unilateral. Which one's easier to win? If it's a mutual mistake or if it's a unilateral mistake? Mutual is easier to prove because both parties are mistaken. Impossibility, which I think the UCC likes to call commercial impracticability. For some reason, it simply can't be done. I can't paint your house. A tornado took it out last week. That's impossible, people. Right? There's still 1 or 2 more. Oh, we didn't cover duress. Tell me about duress. Is there a common law duress and a more current version? You'll probably see on a bar exam the current version, but that doesn't stop you from mentioning the old version. You get brownie points when you say common law duress allowed the defense where there was threat of physical harm to the person or family member or incarceration, imprisonment. Right? See the violence in that one? That was common law duress. What's the one you covered in your contracts book? Economic. That's where they threaten to put you in bankruptcy if you don't sign a modification. Something like that. So today you'll probably see facts of economic, but if I were you, I would say there used to be common law duress, which was imprisonment or physical harm to the person or family member or close personal friend, that kind of thing. Today, usually the concept of duress is in the form of economic duress. They threaten to put you out of business, they threaten to put you in bankruptcy, etc., etc., etc. Okay? But say the first one, but go into the second one, which probably will be. For you to get a fact pattern on common law duress would be highly unlikely. Economic, on the other hand, I think is more likely. But you should mention that it stems from common law duress. It's just that the courts began to realize that economic threats would have the same effect and should also allow a defense to enforcement.
Statute of frauds?
We're going to get to that in a second. Statute of frauds is one, though, you're right.
Illegal.
Illegality is another one, right? If it's illegal, you can't. Now, there are two, maybe three defenses that often seem to be used as if they prevent formation. Remember I said they're defense to enforcement? But they say that illegal contracts are void, don't they? But I can still prove it's a defense to enforcement. You know how? Hard to catch me. You have a murder for hire contract, void. You could probably treat that as not formed. You know what I'm saying? The law will not allow that to even exist. So it's not a defense to an existing contract. It's not allowed. It doesn't exist. Can you think of some violation, though, that's not so bad? And the law says maybe it does continue to exist, and the person who violated it gets quantum meruit. What if you don't have a plumber's license? Isn't that against the law? If you do a great job on somebody's plumbing, right? And you don't have your license, that provides a defense to enforcement because you don't have the right license. But what can you do when it's, I like to say malum prohibitum, not so bad, rather than malum in se, evil in and of itself. Did you guys cover when you had the class the case about the Chicago plumber who didn't have his license?
Sounds familiar.
The guy got quantum meruit. He didn't get the contract price because he didn't have a license. The lady who asserted it against him had a full defense. But they didn't believe there was no formation. They still gave him the right to restitution, this quantum meruit idea. So if it's an illegal contract, you could say it's void. Maybe there's no formation, right? But for the other kind where it's not so bad, it's not so much that we're saying there's no agreement. We're just saying it can't be enforced. But we might now allow another way of enforcement, right? Now let's talk about statute of frauds. Contracts. Certain kinds of contracts have to be in writing, otherwise there's a defense to enforcement. Again, note, you can assert the defense statute of frauds to prevent enforcement, but that is still not the same as saying there's a lack of formation. Okay? Some contracts are so likely to involve fraud, they have to be in writing to be enforceable. That's the language. It doesn't say there's no formation, it says they can't be enforced. Correct? Did you, in property class, did you study a case called Hickey v. Green, where some old lady was going to sell her house for $17,000, and the guy wrote a check? There was no purchase agreement, but he wrote a check, said Mrs. McDougal, $1,700, and he wrote the address down and he gave it to her. And she said, wait, statute of frauds defense? And they ultimately forced her to sell the house to him? Because they said, it's not that she's saying there was no agreement. She's only saying they can't enforce it because it's not in writing. There is a difference. Do you remember that case? It's called Hickey v. Green. And it's in the Duke Minier property book. All right? So, treating it as a difference, one's lack of enforcement based on the defense, The other is if there's no formation, there's no contract. Okay? Are there any other defenses we missed? We forgot to bring up unconscionability. And the UCC has an unconscionability provision in it as a defense. It's also stemming directly from the common law. And what do you need for unconscionability? What kind of facts would you see there?
There's like, tiny words in the back.
Adhesion is a good example where there's tons and tons of words and the person doesn't have a good education. But adhesion's a good thing to bring up, but most important is you want to say that there's unequal bargaining power. Right? Unequal bargaining power. And what's the second main element to that one? It's unconscionable to enforce it in this case because it's just too unfair. Do you remember the quintessential example of that, which might help you on a bar exam? Didn't some lady buy a refrigerator and a stove and a TV and a stereo from the same place? And remember, she didn't have she only had a high school education and she didn't have a lot of money, but she needed the refrigerator for the kids. And she nearly paid off all the other ones. There's one payment on these two or three. But the last thing she bought, she had just bought, and she defaulted. And when she defaulted on that, the people had a clause where they could take everything else away she had nearly paid for. And they're thinking, wait a second. She has no other option but to buy on credit. You're the only rent-to-own place in town. She has a high school education. You've got all kinds of lawyers writing your contracts. So first, we've got unequal bargaining power and no lack of free will, no choice. And secondly, based on the facts, this just is not fair. That's the quintessential example of unconscionability. And if you'll probably see different facts on the bar exam, but you'll recognize the similarities. So you say, wait, I want to talk about the defense of unconscionability for that one. I want to talk about the defense of fraudulent misrepresentation on that one. I want to talk about the defense of statute of frauds on that one. So the facts should guide you to which one of those you're going to be talking about. And if you're not sure, you can say, this is most likely economic duress, but it might work on unconscionability. Spend most of your time on duress, mention really quickly unconscionability, like cover your long shot. And that way, if it turns out to be unconscionability as the right one, at least you were smart and you still said it. You know what I'm saying? Okay? All right. So how many defenses did we just cover? 9 or 10? Something like that? There's about that many. And there's always damage to one party. But the facts will guide you to which one, whether it's misrep, whether it's undue influence, whether it's duress, economic, and possibly common law physical, whether it's a statute of frauds because it's not in writing. Did I say unconscionability already? Yeah. Impossibility is another one. It's gone. I can't paint the barn, it's gone. You can't sue me, the barn's gone. All right? Now, very briefly, I'm going to outline what I think are some of the hardest topics. There's no time to cover all of them. Remember where we started. We started with, against the title, we started with the easiest things you should not miss. Then we covered the categories of main areas of contract law. And if you recognize you're in one of them, as soon as you read particularly an essay, but even a multiple choice, you're already going to start feeling comfortable that you have the tools to finish what you need to do. Conditions. How are they created? Express, implied in fact, based on the parties' performances, or implied in law. So you have to think about, if you have a conditions question, at least briefly talk about how you know there's a condition, how it's created. Then you have to know how/when it operates. Does it prevent the duty from arising? If this is not done, you don't have the duty to pay. That's a condition precedent. Is there a duty that it cuts off? That's a condition subsequent. There's also concurrence, which are usually not that fancy. Okay? Don't forget with conditions as well. If you see a condition and one party is going to go bankrupt and lose everything, what is the court probably going to do? If it can, it's going to look at the condition language and try to interpret it as a promise. Because if it's a promise, guess what doctrine you can apply to at least give them partial recovery? Substantial performance. Right? Quantum error comes in the back end with equitable remedies. But good idea, good thinking, but substantial performance. Okay? Third-party beneficiary rules. Remember when you're talking about third-party beneficiaries versus assignment delegation. If the person's in contemplation when the contract is formed, it's third-party beneficiary rules. If the person is brought in after formation, you deal with assignment and delegation. Okay? Don't forget to talk about intended versus incidental. Intendeds have a much more likelihood as a third-party beneficiary to enforce, but if they're just on the outskirts as an incidental beneficiary, they probably cannot enforce. Okay? The idea of vesting and non-vesting. If I promise to give my niece my check from law school, when does she actually have a right to enforce it? At minimum, she's going to have to know about it. Maybe she's going to have to write Cooley and say, I see my uncle's going to give me his check. Thank you, send it here. So there's a vesting idea for people, even if they're intended, if they don't know, the person who made it has the right to revoke it. But if it's become vested, if that becomes the issue, talk about vesting, yes or no, and if it's not vested, it can be revoked. If it is vested, now that person can enforce it, it can't be revoked. Okay? Assignment delegation we talked about already. Damages. There's, especially with UCC, but not completely, there's a lot of damages issues, right? Don't forget the right to inspect and the time to cure. What if they say you breached, they don't pay you? And they told you that 3 weeks after you delivered them. Does that destroy your right to inspect? Yeah, what if I give you the goods? Let's say the contract they're due next Friday, and I give them you today. And you tell me 2 weeks from now I've breached and you pay me zero. What have you done to me? I still have a week and a half to perform. You just took that away. Now you're the bad person, right? So if you don't inform timely, you might prevent my time to cure, and that makes the breach yours, not mine. If it's non-conforming, but there's still time for me to bring it into conformity, you've got to give me that time. You also have to give me that notice, right? You don't cover this often because there's not enough time. But doesn't that make sense logically? Time to cure, right to inspect. If the right to inspect and the time to cure is over, you're going to be talking about the perfect tender rule, reject, or you're going to talk about probably warranty damages, express or implied. Okay? Remember perfect tender rule. Remember the right to revoke acceptance, and remember warranties. Those are three remedies of a dissatisfied buyer that go in hierarchical order. Typically, when you don't get what you want, what's the best for the buyer to do in a sale of goods situation? Reject, right? The standard is not in conformity with the contract. That's pretty easy to establish, right? Just walk away. Or threaten them, and if they're threatened, what are they going to do? They're going to fix it or lower the price for you. If you can reject under the perfect tender rule, you're gold. What if you put them in your warehouse? You had a week to inspect them. You didn't inspect them, and 3 weeks later you finally inspect them and find out there's a problem. Then what might you be able to do? You can't reject anymore, it's too late. But you might be able to revoke your acceptance. But the standard is harder. To revoke acceptance is harder than rejecting for a non-conforming tender. First, if you're trying to revoke, you have to prove up your right to revoke. You can't just allege it, you've got to prove, right? And the standard is not non-conformity, the standard is substantial impairment of the contract to him or her. So the burden shifts and the level of burden is higher. Now let's say that you can't reject, you can't revoke, or maybe you either can't or you don't want to. If I am supposed to send you feed with 10% protein for your animals, and I send you feed with 8% protein, is the sky falling? Is the world going to end? What do? Feed them the 8% and throw some extra protein in that you got from the hardware store. You're not going to ship it back to me, are you? No, but you can still get me. So you don't want to reject it. You don't even want to revoke it. You just want me to pay on my warranty. So you buy the extra protein, extra 2%, and you just charge me that plus your shipping costs, which is very efficient. So that would be a warranty breach one. So either you can't reject or revoke, or you don't even want to. It doesn't make sense in certain cases. It's better simply to say, I'm going to keep it, I'm going to accept it, I'm not going to revoke it, but you're going to have to pay me my damages based on as warranted versus as delivered. Okay? But remember, in order, usually, the best for the unhappy buyer is rejection. It gives him or her less proof to worry about and much more bargaining power. The next best is revocation of acceptance. And then the least best, but sometimes it's quite appropriate, are the warranty damages. And those are the three. Remember I was talking about the UCC buyer's remedies? Those were the three I just mentioned. Well, not quite the same, but relates there too. Because remember I told you earlier with regard to damages, it was cover or it was the loss of the bargain, which is either rejecting or revoking acceptance, or warranties, as warranted versus as delivered. I mentioned those as. All right. Couple of problems, and I'm going to leave you with these. I mean, I could be here for a decade, but I'm going to give you some special tips on what could be the hardest questions you'd see with regard to sale of goods UCC. All right, and I'm talking now about warranties. And this, I've seen these in cases. I can't recall seeing them on the bar exam though. The standard is generally the damages you wanted were as promised versus as delivered, plus incidentals and consequentials if you're a buyer. Don't forget, sellers don't get consequentials, but they could get incidentals. What's a good example of an incidental damage on a seller? They resell and it's an extra $1,000 to ship to a different state. That extra shipping cost is an incidental damage to fix the problem, isn't it? With regard to UCC warranties, do you remember the ability to exclude or limit? Can you exclude warranties under the UCC? If you say merchantability and it's conspicuous, can you in fact deny the warranty, the implied warranty of merchantability? Yeah, you can. You say it big, say it loud. You have to use the word merchantability, and it has to be conspicuous. If you want to disallow the implied warranty of fitness for a particular purpose, you can just say as is. You don't have to use the term fitness for a particular purpose. Okay? So there are ways of excluding those warranties. And if it's an express warranty, just don't make it, right? There's also the ability to limit. The key with limit is this. If you try to limit a warranty, like you can't get your money back plus consequential damages, but we will repair it or replace it, okay? That's a common limitation of remedy. Now understand the difference between limitation and exclusion, and use those terms properly based on your facts. Here they're excluding the remedy. Here they're only limiting it. The key thing with limited is this. If you try to limit a warranty, but then you still gave one, it's small, it's not all but all. If the warranty you give fails of its essential purpose, it disappears. And all the implied warranties of the code go back in. So if you limit to repair and replace, and you're unable to repair and replace, that limitation goes away, and the implied warranty of merchantability is back on, the implied warranty of fitness for particular purpose is back up, etc. Okay? And there's one last thing I wanted to say. And the standard for that, for a limitation, it had better honor its essential purpose. If it fails, then that limitation disappears, and all the implied warranties come back in full force. And the last thing I wanted to say, I don't think I wrote it up there. No, I didn't. And I'm just about on my time. There's another damages thing. There was the exclusion. There was the limitation. Liquidated damages. And the common law and the UCC are almost exactly the same. So if you remember the basics of one, you can use it like the other. And the idea is, if you have some basis, a reasonable basis on which to estimate the damages, and those damages are hard for a court to estimate later, you're making their job easy, not harder, right? Then the court will honor those liquidation damages, measured, and whether or not it's reasonable calculation is measured at the time of contracting, not what actually happens. Now, the UCC adds we're going to spot check at the back end to see if what really happened is close to what you estimated, but that's probably more than you can remember. Okay? All right, folks, that's it for me.
Thank you.
Thank you.
I'll make sure that Professor Marin finds out how to get this tape available to everybody. And I'll also give him back his LexisNexis thumb drive, on which will be the PowerPoint if you want it. Okay?